Alex here with part 95 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video with the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one large example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This is a video that's going to be pretty short. I could have lumped it into the prior video, but I decided not to because there's kind of a story, I guess, behind it. So what this goes into is my judge's order for me to disclose who the puppet master is. He wants to know what lawyer is doing all of my work. And I laugh not because I think it's unreasonable that he thinks that. I can see any judge doing that. In fact, I laugh not really for anything that he's done at all, but what happened after the fact. After he did this, I guess the clerks got wind of it and they started to call me the ghost lawyer. Eventually, and by the way, it's because of his order. It's an order that wants me to disclose who the ghost lawyer is or what. We'll go into that when we get to the actual order. But anyway, after a few visits to the clerk's office, because back then, this online stuff wasn't really prevalent. And so every filing was me going into the courthouse for the most part. And I was there a lot. And I didn't really get to know the clerks. It's not like we were friends, but I knew their faces and I knew their names. And they were curious about me because I was in there all the time. I was filing stuff all the time. And anyway, once this got filed, I guess the clerk who filed it told the other clerks and they all started to wonder. And anyway, my nickname was apparently the ghost lawyer. And we can thank my judge for that. I found out eventually because it was actually after one of my Supreme Court appeals that I found out. But one of the clerks was like, "Hey, I was reading your stuff." And I was like, "What?" Yeah, he's like, "Yeah, I was reading your stuff." I guess he was like a law student or something. I don't know if that's a normal thing that students do. Maybe, I don't know, work as clerks and stuff. I know that they work as clerks after they get out of law school, but I didn't know that it's a common thing prior, but I guess maybe it is. Anyway, he was reading the filings and he explained all of this stuff that I'm telling you guys now. Apparently, ever since this order about ghost lawyering, that was my nickname around the clerk's office, and I guess some of them, not all of them, but some of them enjoyed reading my filings. I can actually remember now the exact filing that caused him to talk to me, and it was this. It was the order granting sole legal custody. I remember his face. I remember that he was relatively new at the time, and it was a he. But this was towards kind of the end of the process, and this was when I got my order granting sole legal custody. I can remember this now a little bit more clearly. I think at this point, I'm going to just have to go into what the judge has filed. Here we have the judge's order setting hearing regarding child custody and order regarding ghost lawyering. That's what I was talking about earlier. This is a thing, and it is against the rules if it actually happens to be, occurring. But in my case, it wasn't. We'll get to that in a second. Let's just go through this one paragraph at a time. First is the standard introductory paragraph. The court has reviewed my motion to modify and for order regarding education, my ex's opposition, my reply, and my motion for consideration? What does he mean by that? He probably means request for submission. Yeah, it's odd. Okay, anyway, the court now finds, or maybe that's what he's trying to say, maybe is my motion to compel. That might be it. The court now finds and orders as follows. The parties share a common minor child. Pursuant to our order after hearing filed October 19th, 2011. We share joint legal and joint physical custody. My ex having our child from 12:30 until, anyway, that's just the timeshare. Going on to the next paragraph is, this court granted my request to have our child attend Coral Academy. Next paragraph is that I claim that our child did not end up attending school 2011 to 2012, and claim that now the child is attending school at Coral. I claim that my ex is sabotaging our child's education. I claim that my ex fails to abide by the dress code, fails to turn in homework. Child has missed 7 days of school. By the way, this gets worse. So next time when I go back to court, she misses 14 days of school. This is pretty typical. The court doesn't take any action and things get worse. Next paragraph is that, let's see, my ex does not send our child with appropriate supplies to school, indifferent to his behavioral issues, claims, okay, and it looks like he's actually read the kindergarten teacher's affidavit. Hopefully he has. I asked the court specifically to order us to take our son to school unless sick, order us to respect school staff, send the child to school with supplies, uniform, notify the school when he's absent, all the stuff that she's supposed to be doing. I'm trying to get the court to order her. This is a terrible approach, guys. Trying to get the court to scold your ex and get him to do what they're supposed to be doing already. It's 99% of the time it's a waste of time. If your ex does not have their own internal parental conscience telling them to do these things, getting a court to tell them to do it is, quite frankly, inane. What the court needs to do is deprive the person of as much of their custody as they can to protect the child. Anyway, I think I have a video where I talk about that, and I think that video is titled Behavioral Orders. So definitely check it out. I hope that's the topic of the video. I also asked the court to specifically order us to address every disciplinary issue, blah, blah, blah. This is stuff that parents are supposed to do. I'm asking the court to modify child custody, give me primary physical custody. My ex may have psychiatric issues. I'm asking the court to order an evaluation. I can't remember asking the court to do that. I can remember asking the court to turn over all the documentation. Maybe I did ask the court to do that. And if I did, I'm sure I already talked about my thoughts on that in that video. It's kind of fuzzy, but I kind of remember talking about that now. And I know I discourage people, or at least tell people that it's not the pie in the sky that people think it is. I claim that our child's education is suffering. Let's see here. Ask for costs. In my ex's opposition, she acknowledges our son has missed a bunch of days of school. She states regarding the uniform that okay, so this is a lie about giving her one for free. She complains that the school personnel doesn't contact her. She claims she doesn't send the child to school with a backpack because, and then she has her excuses. She claims I failed to communicate, claims that I had to call an ambulance and didn't inform her, yet she knows about it. This is actually somebody in one of my videos posting. It's funny how she says she doesn't know about something that she obviously knows about. Claims that I waited only a week after contacting her lawyer to file. Okay, so there's no time limit. Let's see here. In my reply, I'm claiming that though I communicated with my ex's attorney only 1 week prior, I communicated those issues with my ex directly by email on numerous occasions. In my reply, I claim that our child has missed another 8th day since filing the motion, and that my ex is still not supporting discipline. Next assertion is that I'm trying to get the court to rule on some of my stuff right now and not wait for the hearing. When modifying child custody, the courts have to apply Nevada child custody law, and he cites the law. Any order for joint custody can be modified. The burden on the party seeking modification is identical to that used by a court at the initial custody determination. The court has the discretion to deny a motion without holding a hearing. Okay, so this is the Rooney case, guys. This is the case that I was mentioning I should have talked about, I think in my reply to opposition, probably in my motion as well. It wouldn't hurt to do that. But Rooney is the case that talks about adequate cause for a hearing. Those 5 magic words mean a lot, because if you don't do that, you don't even get to a hearing. You'll get your request denied just on the papers alone. Let's see here. Pursuant to Local Rule 44, subsection 4B, contested motions are to be set for a hearing. The court finds that a hearing is appropriate regarding whether a modification is in our child's best interest, and we have already set the matter for a hearing to be conducted January 3rd, 2012 at 1:30. The court will hear the issue of child custody at the time. together with the other requests raised in my motion. Okay, so he's still not clear here about whether or not that's going to be an evidentiary hearing, and that bothers me. It doesn't look like it is, but it's not clear, and he's not talking about the submission of evidence or hearing the testimony of witnesses. So maybe I can give him the benefit of the doubt, and he is just saying, yeah, your law and hearing motion will be held on January 3rd at 1:30. And hopefully that's what he's doing. It doesn't seem to me that he is trying to say that this is going to be your actual evidentiary hearing. Ghost lawyering occurs when a person gives substantial legal assistance by drafting or otherwise to a party ostensibly appearing improper person with actual or constructive knowledge that the legal assistance will not be disclosed to this court. State Bar of Nevada, and he cites the rule. Let's go into the next paragraph here. The Nevada State Bar has adopted the rule that it is unethical to act as a ghost lawyer unless both the ghost lawyer's assistance and identity are disclosed to the court by the signature of the ghost lawyer under Rule 11 upon every paper filed with the court for which the ghost lawyer gave substantial assistance to the pro se litigant. I am now ordered to file with the court within 2 weeks from the date of this order an affidavit disclosing whether I have been assisted by an attorney or non-attorney and the name and address of the ghost lawyer. Here's the thing, guys. If this was that much of a concern, why did he wait this long to bring it up? I feel like when you're floundering and you're getting nowhere and you're losing, they don't really care. They don't really care who's helping you. Doesn't matter. You're not getting anywhere. So therefore, who cares? But when you actually start to get somewhere, you actually start to get like a hearing, your emotions are being listened to, it looks like you're doing complex discovery, you're executing on your ex's assets, using a writ of execution, stuff that nobody's supposed to know, and you're actually getting orders from the discovery commissioner that are very favorable to you, even though the judge is trying to get in your way at every turn. Now, all of a sudden, since you're successful, now we need to know who's behind the curtain. Who do we need to punish? And this is something that has bothered me since the beginning of my understanding of what unauthorized practice of law was. Because it has always appeared to me that they don't really go after the people who suck at it. I mean, they do, but I mean, comparatively speaking, it raises many more alarm bells for them when the person who is using unauthorized practice of law, when that person's actually successful, they are doing things that are complicated, that they're supposed to fail at, but they're succeeding. That seems to trigger this kind of response more often. Now, I'm preparing this document. There is no ghost lawyer. It's always been me from the beginning, so I have nothing to fear, but it doesn't mean I'm not going to mention to my viewers that this is something that I have noticed. Moving on. We've got the certificate of mailing under Rule 5, which indicates that this order was mailed to both myself and my ex. Actually, it looks like it was mailed to me and it was electronically served upon my ex's attorney. Going into the aftermath, not a whole lot going on here. I didn't file anything, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, I mean, I could maybe stretch and say it took her 15 minutes to deal with this, but I highly doubt that she cared at all. She probably just put it in her court system. There's nothing in there that requires her to do anything that she's already set up. The only thing that matters to her is the date and time of the hearing, which she already knows, which we already counted into her time when we actually did the notice to set. So here we are. All she's going to probably do is put this in her computer system, send an email copy to my ex, and that's it. They don't have to do anything. I'm the one that has to do something. I'm the one that has to file something, but they don't have to file anything. So I think $0 in attorney fees for this particular situation is probably the most accurate and fair representation of what she charged my ex. And so that's going to leave my ex's attorney fees at $0. And so if you have any questions as to my previous videos, feel free to post something down in the comments below, and I will see you guys next time.